very good morning to all of you. I would like first thematic session of this national virtual conference on the theme economic dimensions and judicial decisions. We just had an inaugural session which focused on the economics of judicial decisions or judicialization of the economy. We are beginning the first thematic session on the theme economic analysis of public infrastructure, trade, and constitutional law. We have with us a very distinguished group of individuals who have taken time from their precious schedule and also battling with these extraordinary circumstances under which all of us are living to take our time to be part of this particular panel. Let me begin by welcoming my own colleague, Professor Dr. James Nedumpara, Professor at Jindal Global Law School and Director of the Center for Trade and Investment Law, who has kindly agreed to moderate this panel. We have with us my dear friend and mentor, Dr. Pinky Anand, Senior Advocate, Supreme Court of India, former Additional Solicitor General of India. We have with us Dr. Aruna Sharma, former Secretary, Steel, Government of India, Member, Digitisation Committee of the Reserve Bank of India, Mr. Bipul Chatterjee, Executive Director of CUTS International. As you know, CUTS International is our co-partner and organizer in this conference, and also Dr. Surat Singh, Senior Advocate, Supreme Court of India, another very dear friend and mentor who will be joining us soon. With those words, I'm going to extend a warm welcome to all of you and hand this over to our moderator, Dr. James Nedumpara. Me and my colleague, Dr. Srijit, are indeed available, and we will be listening to all of you during the course of the session. Thank you.
Thank you, Dr. Raj, Dr. Srijit. And I would also like to welcome Dr. Pinky Anand, Mr. Bipul Chatterjee, Dr. Aruna Sharma. In fact, I was supposed to be a speaker in this session, but I turned out to be moderator. But I would also like to add a few, comments about the economic analysis, especially with respect to international economic law. So when we look at the economic analysis of law, it is not a new thing. It has been there for a fairly long period, especially since Richard Posner's book came out in 1974. And when we really look at the economic analysis of law, it is basically focused, traditionally looked at some of the private law domains like a law and contract. So when private parties interacted, whether a party can actually breach a contract if it is leading to certain kind of efficiency, or in certain situations, how can responsibility between two private parties can be assigned or allocated under the law. But in recent times, this debate has also become particularly relevant with respect to constitutional law. Sometimes who believe believe in utilitarian concept of consequentialist legal theories may believe that economic analysis is actually a far-fetched idea. But at the same time, if you really look at the Pareto optimality principle, which finds a very important expression in John Rawls' theory of justice, ultimately the entire purpose of law is to make somebody better off without making anyone worse off. But in every domain of law, this has actually found a very important place. And the two important areas which Professor Raj alluded to is one, construction and infrastructure law. We know that whenever we conduct major infrastructure projects or even construction projects, sometimes people have to be displaced. And in a country like India or maybe in a city like Bombay, we know that this is an acute problem. So even individual rights and liberties come into the picture. And there are many other issues as well, like taking land and other holdings. So when it comes to these matters, to what extent the typical Caldor-Hicks concept of economic efficiency matter is a moot question. But at the same time, we also know that the courts in India will have to deal with this kind of issues on a regular basis. Think about a situation where someone has actually constructed a condominium and the cost of construction is very high, but it was found out later that it was actually an illegal construction. Should it be demolished or turned to rubbles? Or can there be some effective method of disciplining this kind of illegal behavior? Ultimately, if you look at economic analysis of law, the basic assumption is that everyone has to actually become a rational economic actor. It doesn't mean that everyone has to be well-versed in economics or maybe extremely competent in doing this very complex econometric modeling. That is one area which I would like to mention also. If you look at some of the statutes, so being a trade lawyer, I always think about the safeguard statute. According to the safeguard statute, if imports come in large quantity, sometimes it may cause injury to the domestic industry, then of course there is actually a trade remedial provision. But the reality is that the imports are actually coming in because the domestic industry is not in a position to compete. So sometimes the economic analysis, not the economic analysis, the economic approach may not be there in the original statute. Sometimes it is an antithetical concept as well. So in these kind of issues, what does economic analysis actually matter? So we have got an extremely knowledgeable group of people here. Dr. Pinky Anand, I think I will start off with Dr. Pinky. Given your experience of handling very complex litigations in the Supreme Court, would you like to touch upon the role of economic analysis of law in the decisions of higher courts in India? And to what extent courts can actually use this kind of a concept while delivering decisions? Over to you, Dr. Pinky.
Very tough question in a way. All said and done, we have a constitution. All said and done, we have statutes, we have legislations. They've incorporated the basis on which lawmaking or law and justice should prevail. So basically, the entire enumeration of analysis by courts of rights is based upon the legislation as it is provided, and of course the test of the legislations against the constitution as and when required. Having said that, I think the real domain when we enter into this discussion, and you're right, there is this entire conflict as to what is a better model to look at. Social welfare is inbuilt into our constitution, and all kinds of legislations have taken that into account. The constitution and the courts increasingly have been enlarging the compass of Article 14 and 21 to heighten human pleasure, if you like, or human welfare, public welfare, social justice in all manners. Infrastructure and construction possibly are a different domain. Workers is another domain. Migrant workers is another domain. COVID situations is another domain. Healthcare is another domain. So, you have this entire paradigm of issues. So coming to the question back at hand, you have legislation which incorporates the rights on the basis of which judgments are rendered. But you have another domain, which is where the courts step in. Now, these are two basic dimensions. So the second dimension is public interest litigation, Article 226 and Article 32. And the third is Article 142 of the Constitution, which allows the Supreme Court to do complete justice between the parties. So broadly speaking, it is only in these three domains that courts can enter into an economic analysis in any manner whatsoever. Otherwise, frankly speaking, according to my understanding and according to my understanding of the law as it has happened, the entire interpretation of law is based upon the existing laws. But when you come to the areas of public interest litigation, which is of course manifold at this point of time, right from 1980s onwards, I think we've been experimenting, and this stretches across all domains. So for example, in issues where you're talking about industries, let us say closing down. Now, as an example, or you're talking about firecrackers industries, you're talking about Diwali, you are talking about Arjun Gopal's case, which was given, I was a party to that case also. And the whole question was, can you, in the interest of the public and health and environment, shut down the firecracker industry? And indeed, the court did do so. The pollution levels in Delhi were so high that it was killing by itself. So even at the cost of an industry shutting down, the entire basis was made. So courts also, I might say, do lean more in favor of social welfare than in favor of possibly sheer economics of industry. And I think that indeed is a thing that we require in this country. In India, we are dealing with a 1.3 billion population. We are dealing with a class difference between different classes of people and status in terms of whether economics or whether living or whether availability. So the essentials that are being taken into account by the court in economics, if at all in the jurisdiction of PILs and other jurisdictions that I mentioned, it is still veering more in the line of social welfarean economy, which is the manner in which we proceed. So you will find several examples, particularly in these COVID times, as I said, whether you talk about the Vande Mataram flights which are going to bring in children across from other countries or people across from other countries, whether you're talking about the safety and welfare of healthcare workers, whether you're talking about the availability of vaccines, whether you're talking about oxygen supplies. So the entire focus broadly in this jurisdiction is of social welfare in nature, and possibly that is the right thing to do. As far as issues of economics is concerned, sheer economics and commercial, there I'll bring in two aspects. One, again, in the current context of COVID, it becomes rather imperative to be constantly talking at this point of time because we are dealing with the situation. The government, for example, so the first leg is the government. The government took into account the difficulties that were confronted on account of COVID conditions and came out with several circulars and guidelines, which A, dealt with COVID as a force majeure condition. So force majeure kicked in to help people in terms of commercial or other transactions which were economic in nature. Two, again, the government came out with construction contracts and the question of extension of infrastructure projects, because ultimately it was realized that the benefit to the economy would be on account of infrastructure projects which could carry on rather than any kind of termination which would come on this account. So in these two domains, the legislature and the government and the executive came out with its policy as far as economics was concerned and law was concerned to alleviate the difficulties that happened. As far as the courts are concerned, I have already mentioned some of the features that the courts have gone into. But currently, I'll just talk about one of the cases, which is, for example, just now, which came up before the court, the Vedanta case, for example, which talked about setting up an oxygen plant to supply oxygen at the time of crisis and the unavailability of oxygen to the hospitals and the patients, the COVID patients. That is again a question which needs to be considered. There are several other issues that I've been hearing about. For example, setting up additional healthcare facilities by private citizens who want to cooperate and collaborate with the government in order to provide assistance. There are hiccups in that direction. And the third direction that I think I'll just flag for the time being is the crisis always between social justice and development. Now, that is a constant kind of conflict. For example, in construction projects, the displacement, as you mentioned, the construction of buildings. So you require roofing or you require a roof over the heads of people, whether it is employees, whether it is government employees, whether it is private citizens. And B, you have the question where there's a conflict with the environment or other conditions like traffic, congestions, which also lead to pollution and other environmental issues. So these are the kind of questions that are confronted by us all the time, and we are actually grappling with it. But the jurisdictions within which we can do, as I mentioned, is the jurisdiction of PILs, 226, 32, Article 32, and then again Article 142, where the court can kick in justice to bring in parameters. And there you can consider other aspects of law.
Thank you, Dr. Pinky. I think that was a very insightful observation, actually. So what you're trying to say is that in India, most of these actions, especially through Article 32, Article 142, and all these instruments are basically used in order to advance the social welfare. But sometimes the social welfare may be concentrated, sometimes it may be diffused in nature. So you spoke about a decision to, open up an oxygen plant in one particular place. And the local community in that area may be rather opposed to that idea. Or maybe, it's very similar to a situation where someone actually set up a waste disposal plant. The local community is up in arms. And that waste disposal plant was actually, it was shut down. And there are, of course, negative externalities. I think people are throwing the waste, the garbage into the public area. So there could be consequences as well. So in this kind of matters, I just wanted to ask you, when multiple interests, multiple stakeholders are actually involved, and when a court like the Supreme Court of India exercises the jurisdiction, which may have a pan-India impact, to what extent it is actually possible to take into account the various categories of interest vis-a-vis the concentrated interest?
That's not an easy task. In a diverse country, in a country such as India, where you have all classifications of people and all classes of people, and I mean this in economics, in sheer terms for the time being, or in terms of facilities or utilities being available. So it's a very tall order. But I think, let me give you an example of what I think the Supreme Court or any other court can and does do. When you evaluate interests, the question is of balancing interests. You can't have absolute exercise of any right. So, for example, when health issues come in, when security issues come in. Now, these are just two concerns that I'm flagging for the time being. If you talk about health and security, they have to take precedence. So you have to have the health and security as primary considerations, particularly for a sovereign nation like India. I keep coming back to health. I can't avoid that focus. But as I said, even security, for example, for security, if anything is required, whatever means are required to adopt to gear in that direction is something that we need to step towards. Whatever directions we need to head as far as health is concerned. I'll just tell you for a moment. I was actually, this question I was confronted with in Arogya Setu as an application. And the question was of other concerns, divergent interests like privacy and other issues which were coming up. Now, the question really is then, and this came to my mind, that there cannot be any ambiguity in this direction. You have to give precedence to health. And if any method is adopted, which for the time being in such a crisis and emergency, can alleviate misery in any fashion or help the people in any fashion, that has to be given precedence. It has nothing to do, and this is not economic, I'm so sorry, this is another concern. So these are the kind of grappling issues that the court has to grapple with at times. Now, for example, the supply of oxygen, the interstate movement of oxygen across hospitals. These are all the issues that the court does deal with. And you are right, at various times, the court has its own limitations in the sense of how to balance the interests, how to consider the balancing of interests, the question whether it is policy making and the courts can enter into that domain or should they enter that domain. But I think there comes a benchmark. There comes a Lakshman Rekha, so to say. And at times you have to cross the Lakshman Rekha because there is an emergency situation which can't brood any delay. So you have to take action at that time. But in normal circumstances, what happens? But let me just give you an example there. What the court very frequently does, as it has done in the case of transport, pollution, environment, is have an amicus to assist the court. And it has happened in several cases. I myself have acted as amicus in several cases which involved either water distribution or literally the interwater situation as far as the country is concerned. So the court very often takes the assistance of an amicus to take the issues of various interests into account. But believe me, it's a tall order. I really struggle myself at times because it would be such a hard position to take that you take one interest in that sense and to balance it against the interests of certain other stakeholders. So somebody or the other is always unhappy. But the point is, you have to see the social good. That you take the public good. This is the typical Socratic kind of an Aristotelian concept. Public good is what has to be seen. And as long as that is done, even if there is some possible harm or hardship caused to the other section, that has to be for the time being bypassed.
Thank you, Dr. Pingy. In fact, very useful. I think you spoke about the importance of prioritizing interest, and some interest like health definitely will trump over other rights, and they will have to be actually given certain amount of importance and weightage. So very valid point in terms of the obligation of the courts to balance various categories of interest. So now let me turn to Mr. Bipul Chatterjee with Cuts International. And given the field that it is, this is actually my own field, international trade law. And one of the maxims is that in international trade, neither law nor economics matters. It is basically political experience. What works in a particular negotiation will ultimately decide the text of the agreement for that matter. So, Mr. Chatterjee, in your experience of handling trade, international trade and economics for a fairly long period of time, do you feel that the existing mechanisms, the courts in India, or maybe even international tribunals for that matter, are competent to provide an economic analysis of trade agreements or in the context of the domestic statutes and interpretation of the domestic laws? Over to you.
Thank you, James. I'll stick to the question which you have posed to me. But before that, let me very briefly talk about one very important point, and that is also related to the question which you have just posed, that any law should be made in a manner that it is Pareto superior. That nobody, at the end of the day, the net benefit should be there. Of course, there will be some losers, there will be some winners, but there should be net benefit. At the same time, we have to also keep in mind that those who are losers, how are we going to compensate them? Is there any provision in a particular law to compensate the losers in the short run and also in a dynamic manner over the medium to long term? So that's the basic premise which we have to keep in mind. Now, coming to your question, I agree with you that, and also disagree with you in another sense, that it is true that when it comes to international trade, economics sometimes doesn't matter. And that is evident from the various negotiations, trade negotiations with which we have involved with. At the end of the day, what matters is the political economy of the subject. And also you have to look at various subjects together. I can give you one or two examples that when the TRIPS agreement was being negotiated at the CAT, we were aware of the fact that it is going to be harmful, at least in the short run, it's going to be harmful. We are going to face a lot of cost as a result of that agreement. Then it was also pointed out to us, by us, I mean India, that we'll get compensation, we'll be compensated through the gains that you are going to get from the agreement on textiles and clothing. So this is the balance that we are talking about when it comes to international trade agreements. Now, it is easier said than done. How are you going to reach the balance? Let me give you one personal experience which I encountered in 1997, the winter of 1997, during my first visit to Geneva. There was a meeting at the WTO's building. And after that meeting, there was a session. A number of very eminent speakers were there. I couldn't gather much courage to pose a question to one of them. So that question was bothering me much. But after the session, I could meet him in the lobby, Ambassador Julio Lacarte, one of the stalwarts of international trade negotiations, trade agreements, one of those three who drafted the Havana Charter in 1948. So I asked him, Ambassador Lacarte, what you have discussed is not making much of economic sense in terms of economic theories which you have studied. And his answer was simple, that my son, in this building is the politics which matters, not economics. So that is something which you have to keep in mind. Therefore, James, I agree with you, but at the same time, you have to keep in mind that how are you going to marry law and economics together? And there, I think we have a long way to go. I studied in one of the best institutions in India which teaches economics. There's a course, Economic Development and Planning in India. And you'll be surprised, or may not be surprised, to know that nothing was taught about economic laws. So that's, if not the best, one of the best institutions in India. And that was more than 30 years ago. Now today, when I look at their course structure, still it's more or less the same. So my point is, our economists, they do not know much about the laws. Even when we are taught social welfare or issues which are very much competition issues, for example, we are not at all aware about the legal implications of various provisions which are there in our laws, or the economic implications of those provisions. And therefore, I don't know about the law schools. I shouldn't speak about them since I don't know from inside. So, so this is where the system is. So what I think which we require is systemic reforms in our education system in general, but in in terms of the teaching of economics as well as sports. And only then we can have a better understanding before passing any judgment on an issue which have various conflicts of interest. So there will be costs, there will be benefits. I don't know whether cost-benefit analysis is done before passing any judgment on specific subjects like this Starlight case. Have we done any cost-benefit analysis? I don't think so, because systematically it is not. We are not taught, or we are not tuned to do such kind of analysis. So therefore, I will end by emphasizing on this point that, and this is also related to our trade agreements or trade negotiations. Before entering into any agreement while negotiating, do we look at the kind of changes which are required in our laws? Or are we making our commitments without understanding their legal implications? To tell you honestly, James, I don't think we look at that holistically. That requires a lot of work. And not just the work, it has to have a system in place. And some of this system, not just the whole of government approach, that's one part of the story. The system which includes the involvement of not just the executive arm, but also the judiciary arm, the administrative arm, the industry, the academia, the whole ecosystem, which is still very much missing in our country. And I think that's the root cause of all problems, all issues, knee-jerk reactions that we are facing today. And unless it's not going to change over time, we have to have a vision for over a period of 10, 15 years to overhaul this system so that we can have a much more holistic understanding about issues. And going back to your initial point, to make laws in a manner that they are parental superior. Thank you, and over to you.
Thank you, Mr. Bipul. In fact, I will have a follow-up question, and of course, I will have more questions later. So you made some very valid observations. And the first point which you mentioned is that in any kind of a trade negotiation, obviously it is basically a matter between accommodating the interest of the losers versus the winners. But as a think tank, that advise the industry, the civil society on the possible outcomes of trade agreement, do you often anticipate difficulties in telling the losers that you are likely to be a loser in this particular trade negotiation, but there are overall economic welfare gains from the country signing that agreement? So maybe I think that is a very important issue, and that is why we are facing huge amount of backlash against various international trade agreements. There are so many examples in recent times. And second is the point which you mentioned, that the economic analysis of law in the current context is always spoken about providing a kind of an interpretation which is informed or inspired by economics. But my own understanding is that when we think about economic analysis of law with respect to trade agreements, there has to be an ex-ante analysis of the negotiating text. And that negotiating text will have to, I just try to predict or project what kind of, consequences or good effects will come out of the agreement. So, being a central figure in the civil society movement in India, how do you basically communicate with the concerned stakeholders about the outcome, the economic outcome of a trade agreement that is actually in the making?
On both points, I agree with you. The answer is yes. But how do we do it? That's the question. We do it in a transparent manner. Your questions are related to each other. For example, in case of U India FTN or BTI, whatever you call it, we did ex-ante analysis, sector by sector analysis of what will be the impact of this agreement on these sectors in India and what will be the impact on household income. The tools are there, the data are there. It's not difficult, it's time consuming, it's laborious, but it's not difficult. Now, based on that, you have to do, which we always do, and Commerce Ministry also, they also do. You have to do stakeholder consultation, large scale stakeholder consultation. I'll give you one example. You remember during the peak of the Doha round of negotiations, there was a discussion in case of industrial goods, the so-called NAMA, which is known as NAMA, non-agricultural market access, which effectively means industrial goods. There is a proposal by the United States and many other countries to have a sectoral approach. 0 on 0, 5 on 0, that you reduce your tariff to 0 on certain tariff lines, certain products. We will also reduce our tariff to 0. You reduce your tariff to 5%, we will reduce our tariff to 0%. So before taking any position, I'm sure James, you are part of that UNCTAD project. Huge amount of consultation. First, the groundwork, the research work, secondary database research work. Then extensive consultation was done all throughout the country, led by the Commerce Ministry, supported by both FICCI, CII, other business associations, and civil society organizations like us. And at the end of the day, we found that there are certain sectors who are open to this, there are certain other sectors who are not open to this. But net, on balance, most of the sectors are not open to this approach. So that's how we took our position. Now, when you talk to losers, the most important thing we need to understand and do that what about the adjustment program? In a country like India, after 70 years, after doing so many negotiations, we are yet to come out with a trade adjustment program. And this is the point which you have been conveying to the Commerce Ministry for a long time. But some bits and pieces are happening, but you have to have a very holistic approach for a trade adjustment program. Many countries in the world, including developing countries like Kenya, like Ghana, they have this kind of approach, like South Africa, like Malaysia, Indonesia. So they have, if not robust like United States or many European countries, but at least they have that. So we have to have data-based trade adjustment program. It's not a difficult thing to do. You can also ask for revenue compensation for running such a program, that you can build in that kind of a provision for a program like that, so that over time, users can gain new skills, new employment opportunities, new livelihood opportunities. And there is an overall consensus in the country before going into any trade agreement. Over to you, James.
Thank you. Excellent point. Again, I think the point which you mentioned about the trade adjustment program is absolutely valid. In any way, it is actually part of the political bargain. And my own feeling is that if anyone has actually lost out, then, like the social benefits they get in their bank account, those kind of losers should be given a cash grant. I mean, that's an idea worth exploring in a way. So now let me actually talk to, let me bring in Mr. Surat Singh, again a very eminent attorney in the Supreme Court of India. So my question is specifically with respect to some of the procedural issues, like the interim applications, interim stay. One major complaint about our own legal system is that the proceedings never get completed on time. So generally in the economic analysis of law, we look at the outcome, basically the the approaches taken by the judges in their final decision. So, Mr. Surat Singh, can you actually talk about the interlocutory orders, the kind of delay and other kinds of embedded problems within the system that actually lead to loss of economic welfare? Can you touch upon these issues? Are we having some kind of a technical glitch?
Can you hear me?
Yeah, I can hear you.
Yeah. So when people say, oh, in India, cases take so long, 10 years, 15 years, then the question is, how come why people go to court at all? If it takes that long. And the reason is simple, that great lawyers like my friend Pinky Anand, they get you the interim relief on the very first date. So if you get what you wanted after 10 years on the very first date, you don't mind the delays. And that's why interim application, I was teaching a course at Jindal University itself, are the critical aspect whether a lawyer is a great one or not. But then, of course, there are consequences. Those who benefit from the interim injunction, as Professor Chatterjee rightly said, they are losers. Those who keep on waiting till they are heard. Now, when we talk about economic dimensions of judicial decision, I totally agree with my predecessor speakers, Pinky and Mr. Chatterjee. However, let's go to the first principles. What is economics? Economics is when there's a choice between competing interests and what is the best use or optimum use of scarce resources. So whenever any intelligent, rational choice is involved, economics is involved. So now question is whether judges are making intelligent decisions, at least where economics is involved, with great respect. Yes and no. Like, for example, let me start with my Harvard Law School experience. During New Deal era in 1930, when President Roosevelt said that, look, we have to change the laws and we have to come out with the new regulations limiting hours of work and others. Supreme Court said no. In Shelter Bolting case, Supreme Court in 1935, American Supreme Court said, we are asked to look at the economic realities of the country, but we have to look at the Constitution and the exact language. The exact language of the Constitution does not allow us to look at the economic facts. And they decided against the Roosevelt administration. And when this entire thinking of packing the court started, then same judges, one judge, Justice Sutherland, changed his attitude because he was about to lose his job. And he said, we cannot shut our eyes to the economic realities. The same law was there, everything was there, but the orientation was changed. Same Supreme Court said, we cannot shut our eyes to the economic realities of the country, and laws should follow what the realities are. And Justice Krishna Iyer in Indian Supreme Court over and again said, law must always follow life. And life means economic realities. Like, for example, and unfortunately, our judges are not oriented like that. Our judges are oriented thinking like a lawyer. We look at the black letter of the law, or what I call text, instead of context. Mr. Chatterjee invited us to look at the context, look at who are the winner, who are losers, how to compensate that. That is really functional approach. But I'm sorry to say, Indian Supreme Court for first 23 years did not adopt the impact approach at all. Their approach was, look at the text of the law, whether a law is valid or not, what will be the impact, we don't care. Thanks to great lawyer Nani Palkiwala, in bank nationalization case, he said that we have to see not the language of the law, but the real impact on fundamental rights. And then the entire approach of the Supreme Court was changed. Now that orientation is needed, that approach is needed, as Mr. Chatterjee rightly said. For example, I was arguing a case on behalf of power sector. And I said, we can have huge $16 billion investment in India, but the investors require internal rate of return at 16%. Judges at the Electricity Commission said, wait a minute, rate of interest on savings in bank in India is 6%. Why we should give them 16%? They could not understand that risk is involved. In bank, savings bank, no risk is involved. That's why 6% is okay. But if you are inviting foreign investment in India, which was politically very volatile at that moment, then internal rate of return 16% should be there. But there was no appreciation of internal rate of return. So similarly, now we celebrate that Supreme Court intervened in 2G, 3G cases. I'm not a political person, but the allegation was that there was a loss of 1,71,000 crores. But when they were really offered in the auction market, how much profit came? Only 17,000. And the entire thing was stopped. We could have been ahead 5 years, 10 years, had the whole thing in 2013, 11 have been allowed. So, but court was not looking at economics. Court was looking at whether any irregularities were committed or not. So the approach of a typical lawyer and the approach of an economist are two very different things. And as famous economist John Maynard Keynes said, that a person who says I am legal, a person who says I am practical, and I will not look at the economics, is probably a victim of some defunct economist. Because you can't avoid the economics in life. Only thing is either you do in a self-conscious, well-informed manner, or you do it in a kind of intuitive manner, which is sometimes may not be well-informed. So my point is, let our judges be much more well-informed about economic aspect, about cost and benefit, so that they can come out with the best decision. For a better decision, we need law, we need economics, we need understanding of politics. And that's why legal profession, on the one hand, is a learned profession. On the other hand, it's a practical profession. So sound common sense should never leave us when we make judicial decisions. And in sound common sense, economic dimension will always be included.
Thank you, Dr. Surat Singh. It is extremely interesting.
I want to add something here.
Please.
Surat, you and I have gone a long way and seen each other, but I have some comments on your statements. As I mentioned, James, in the first instance, my general belief is one, that we have a system in the country and possibly anywhere in the world, including America and all the very forward-thinking judges. When you have legislation in place, that legislation, as Mr. Chatterjee rightly said, that legislation must be considered and made keeping in mind all the stakeholders and consulting them. But once the legislation is made for law and the rule of law, you have to have an objective criteria. You cannot have a common sense or any other kind of approach which is a completely subjective criteria, because that variation is something that we cannot look for. What we can hope to do and what we should do, as we have done, for example, in the ease of doing business. Now we have jumped up several notches and we've come to the 63rd position as far as the country is concerned. And I'm definitely not talking about current COVID times. I'm just talking about the pre-COVID times. So India did pretty well on that respect. India took decisions, very strong decisions for demonetization. India took very strong decisions for imposing GST. So you have one tax, one country principle which prevails, which has alleviated the hardships of doing business. But having said that, the domain of the cost-benefit analysis would remain in the hands of the government and the legislature while doing so. The process of doing so may be improved, that is one aspect, but nothing beyond that. Second, I think what we have to grapple with is ultimately ensuring that India is a friendly destination qua business. Now, when we talk about either trade or we talk about contracts, the question one of enforcement, and two, as Mr. Chatterjee rightly mentioned or Surat mentioned, the question of ensuring doing away with delay. Our principal downfall, as the Whiten case has shown us, has been the delays in the system, which seem to evoke a number of responses from the business community, if not others, to say that India would have difficulties because of the enforceability. Again, to add a caveat to that, we have in the recent past made several discussions and come up with laws. For example, the Commercial Courts Act. For example, amendments in the Arbitration Act. That has been a major discussion that has been happening across board, both by the legislature and by the construction of courts, in ensuring that there is as minimal as possible interference in an arbitral award so that the same can be enforced. We've also had, for example, an executive policy called the Niti Aayog policy, whereby the amounts that were due would be paid pending the resolution of disputes. The fourth aspect, which I think has been flagged by you, the stays. I think that is something which has proved to have its own consequences. So, for example, in the case of stays, what happens is, by and large, there are stays, and I'm saying particularly in the context of infrastructure or construction or contractual obligations, where stays can harm economic benefits to any section of society. Aside from the social, I'm not going there for a moment. So on the economic aspect, the courts have been now time and again emphasizing. In particular, I was in fact a party to the case of the Asian resurfacing, which was decided by the Supreme Court to say that stays should not be extended beyond 6 months. And if stays are extended, the same should be by a reasoned order, which should follow. This was, of course, in the context of a criminal case, but subsequently the Supreme Court has clarified, I believe Justice Kaul has clarified that the stay would be not only for criminal matters, it should not be there for beyond 6 months in criminal matters as much as for civil matters. So the entire perception of the system, as I said, the first part being substantive and the second part being procedural. Yes, we have to minimize the delay so that the matters can get disposed of. According to me, certainty and disposal of matters results in much more satisfaction for the economic coefficient or the social coefficient. So just as an example, I was a member and a party to two of the cases that dealt with two huge construction projects in the city as far as Delhi is concerned. In both cases, the stays were granted for almost 2 years, and we were in fact fighting for the stays to be removed so that the work could go ahead. The projects were midway through. They were suspended during the hearing because of the stays granted by the courts, and the economic cost was phenomenal and ran into thousands of crores, as well as the hardship to the number of people. So I think that analysis is something which we have to definitely work on to ensure that whatever we do, for example, a suggestion on that aspect, in construction projects, in infrastructure projects, there should be almost no question of stay beyond a very, very limited time, if at all. The idea and the perception should be to dispose of the matter without the legalese that might necessarily come in the way. The reason is that stays can be prolonged because of various reasons which we should avoid. So we need to have a quick, efficient disposal of system for the rule of law to prevail, and that would be economically extremely beneficial to all sections of society.
Absolutely.
Thank you. Thank you, Dr. Pingi. And again, I think this was one point which I wanted to ask Dr. Surat, because stays are actually given based upon the balance of convenience at that particular point in time. And if stays continue for a longer period of time, of course, it can have a significant economic consequence as well. So I think some of these points were already addressed. If you want to touch upon anything beyond that, please go ahead.
I just want to add that I think increasingly courts are becoming very conscious of the fact that stays granted by them in economic or commercial matters would cause hardship. So the current broad trend is definitely to ensure minimal stays. And as I said, for example, the example of Niti Aayog policy in arbitration matters, that you do have the system of the government and the courts collaborating to ensure that the various amounts are not held up and the projects are not held up on account of what is going on. So that consciousness is evident. I mean, I've done few matters, for example, where the courts have refused to grant stays in matters where there is a continuing performance, or there is, for example, a cancellation of contract, or for example, where there is a fresh tender to be invited. In all such matters, the courts are quite cognizant of the fact that this would have an economic loss to the entire situation. In one matter, for example, which was dealing with the highway across Bombay and Goa, as far as infrastructure project was concerned, and the highway was to be constructed, on the ground of the benefit and the cost benefit analysis, the court expedited. See, the court cannot go beyond what is provided. Now, for example, in environment matters, we do have an EIA, environment assessment analysis, which is required as a matter of law, and we have certain criteria which are required to be fulfilled. So what Mr. Chatterjee said, possibly a cost benefit analysis is something that should go. but that cannot be a factor in normal cases as far as law is concerned in courts. It can be a matter for the legislature or, as you suggested, a think tank to put into perspective what should be taken into account while making. But after having made a law, the same has to proceed on that basis, and that would be the only manner in which it can proceed. Economics being a factor in consideration for the legislation, but the enforcement of it being in principle based upon the letter and the context of law, no doubt, but nothing beyond that.
Okay, Dr. Surat Singh, do you have anything to add?
Yes. Two points. First of all, as usual, Pinky has given extremely insightful view at the entire picture. And one new development is that now arbitration is turning out extremely helpful in reducing the delays and also in dealing with stays. For example, in recent one project, arbitrator gave a substantial amount to our client and whatever other party wanted so that the customers do not suffer. Now, court would have taken a long time, but arbitrator did it. So I strongly suggest that economic aspect is most relevant in arbitration issues, where judge informally can consider what are the costs and benefits regarding. So that's one thing. Another thing about, as Pinky pointed out, environment. Environment I have done on the side of environmental preservation. But so I have been much more pro-environment. But now I am realizing that in the name of the environment, economic development suffers. For example, I did a case where because of loss of 5 lakhs trees, the entire project of 862 crores was not only stopped, but quashed. Now, since I was on side of the environment, I was quite happy. But today now I realize that had Supreme Court been more sensitive to both environmental preservation as well as economic preservation, economic development, things would have been better. For example, they could have asked the builder to grow more than 5 lakh trees instead of stopping the entire project. They could have charged them with the responsibility that, okay, you are taking away 5 lakh trees, you now do at least 10 lakh trees and court can supervise. So then economic development would have taken place as well as environmental preservation, because I believe nothing is more polluting than poverty. And creating prosperity, what I'd say shared prosperity, should be declared a fundamental right in that sense. Shared prosperity, it means not just prosperity, because in America there's a lot of prosperity, but the benefits are not going to various sections of society. So I call it shared prosperity should be a goal which Supreme Court should consider along with other goals. And that sensitivity is required, because had the Supreme Court paid attention to economic development, they could have very well said, okay, Dr. Singh, you are saying loss in 5 lakh trees? All right, we order them 10 lakhs, let the project go, and employment for thousands people will continue. So more sensitivity is required towards this striking of balances, taking them together, harmonious interpretation as far as possible. But I totally agree with Pinky in the sense that it is not just common sense in isolation, in vacuum. Common sense in the light of the text. So that's why both text and context are important. Text is a good starting point, but the journey should not, interpretation should not end there. It should look at the context and try to make sense of the text as much as possible. Looking only at the text at the beginning and the end is not the right approach. Purposive approach, why the laws are made for legislature, what purposes they should satisfy, what are the best way to satisfy those goals, would be a much better approach.
Thank you, Dr. Surat Singh. Extremely interesting points, that law should not be interpreted in a pure textual manner, but you have to take into account the overall well-being of the society as a purpose of the law itself. That is a very valid point. Let me now turn to the next speaker, Dr. Aruna Sharma, former secretary to the Government of India. Ma'am, given your experience of working in the government and also working with some of the regulatory agencies under the Government of India, do you think that a cost-benefit analysis can be undertaken before preparing government policies and plans?
Absolutely. I definitely endorse and I'll elaborate it because now I've been taking up the case of Goa mining issue and I'll take the example from there and build up the case. Now, if you look at the Goa mining issue, if you look at it, a state which had the highest per capita income and a state government which never had to borrow money, we have reduced it to a little less than the lower per capita income, as well as the state borrowing nearly 6,000 crores to run their business as a state government. Now, why did it happen? It is just that there are two cases pending in the court. One is when the Goa merged with India, what is commonly known as the Abolish Act, and the second is the interpretation of MMDR Act 2015, and the entire mining operation in Goa, which is 100% export business because it is there is no issue of environment involved there. And they have got the certificate of best environment internationally of maintaining and doing the mining practices. But in spite of that, a sudden guillotining it because of the two interpretations, where in the erstwhile Portuguese state, they had a lifelong lease available. When the merger happened, it was committed to honor that. The MMDR Act honors it for those like Tata and SAIL, where they have got the lease for a number of years, but have not honored for Goa miners. And suddenly a guillotine has come. Now, what it requires is to do this economic analysis and the court to do a fast harmonization between these two judgments and then come to a resolution. Now, this kind of economic analysis is the need of the day. And with my highlighting this, now Niti Aayog has also constituted a committee to look at the economic loss which has come due to some of the judgments that has happened. Having said that, I will say that the mechanism in which the courts work, it is very important for somebody to bring this to the notice of the court. One could have been through the writings, because in the two parties it did not happen. And in the Goa case, they did have day-to-day hearing. But what is the end result? No judgment has come as date. It has not seen the light of the day. So the perpetuity and what was rightly said, the poverty is setting in. In a country like India, where 65% population is young, and we have to create the employment opportunities, this kind of a delay, which required just to sit down with these two acts along with policymakers and come up with a clear-cut interpretation, impacts adversely in the economics. Another example I'll give you of the Karnataka case, where there was an upper cap kept on the amount that you can mine, iron ore mining you can do. What was the impact? The iron ore was much more expensive in Karnataka than in Chhattisgarh and other states. With the result, the secondary sector who is processing the iron ore to make steel, you had more than 70% plants closed down, employment loss, business loss. Now, these are the kind of impacts why I'm highlighting these two cases to take the matter further. And today, and I'm taking the current live cases. I'm not going into the history of it. So it is very, very important to bring this economic analysis aspect into it. And this also builds it in the Constitution. If you look at Article 41, which ensures the right to work, or if you look at the Fundamental Rights, Article 37, Fundamental Duties of Article 37. Now, if you're looking at the fundamental duties, it is talking of inclusive growth, which they said the shared prosperity. So if you call the inclusive growth, then it is very important that these kind of delay in decisions, which is going to have an adverse impact on the economy of the state, or also the kind of decisions where you have a very, very serious matter, like you now look at the current status of e-commerce issues. Now, e-commerce issues is getting so complicated today because we are coming up with a new direction every time, and then people are rushing to the courts. Now, that is not the way, especially the COVID has proven the importance of e-commerce, and the digital payments which we were able to put in place has been like a boon to give a fillip to this e-commerce kind of a platforms. So therefore, it is very, very important that when we are looking at these kind of things, the economic aspect in the legal frameworks has to make an appearance in these kind of cases, which is going to have a very, very adverse impact into the economy of the state, as well as the economy and earning capabilities of the youth or citizens of that place. The delay in the infrastructure projects, right? The acquisition, the land acquisition. Of course, we have to protect the rights of the people. We have to ensure that proper compensation is being paid. But a delay in road construction, I remember once I've said, it is losing of an opportunity to the citizens there. We are not able to give them a connectivity. A delay in connectivity may just sound that, okay, the road project got delayed by 2 years, 5 years, 10 years. But we are forgetting that whole entire population could not have an easy access to the opportunities across, or to sell their commercial products easily, or to sell their produce easily, or to graduate up into their commercial product. So therefore, especially, I think the beginning point can come up from the point where there are the economic principles involved, the economic hit is involved, to have a look into these cases and put them into a fast track. I totally agree what Pinky Anand said, that while legislating, it is important to get the perspective of all stakeholders. But many a times I am finding, unfortunately, that they are trying to use the shoulder of the Supreme Court to decide the issue, what could have been decided by legislation or by the executive orders. So this also the court should discourage, which causes delays or results into a ping pong battle. And the kind of examples I gave has having an impact into it. If you look at it, there has been some very, very good judgments from the court, which gave a trigger to the economy also. So these kind of judgments should be documented, should be highlighted, and should be used as an exposure to everybody. There was a mention about the forest and the trees being cut. It also needs a lot of education. I also got educated at a later space when I realized that, as long as iron ore is there in the earth, only blade of grass will grow. But the moment you take out the iron ore, you can have a thick jungle there. So 30 years down the line, we can have, or 50 years down the line, we can have a thick jungle there. So this kind of an understanding, even in the environment issue, is very important. When we are moving ahead with this. And I have found that when we brought this to the notice of the court, we were able to get favorable judgments or all comprehensive, holistic judgment. But then question comes is, should it be an auto route or should it be a special effort route? That is where I like to say at this moment of time.
Thank you, Dr. Sharma. I think, again, a fairly useful insight from you. One question which I have, basically you pointed out the issue of delay. And when you really look at delays again and economic loss, one major problem is that with respect to every government policy measure, there has to be some kind of an economic analysis. And if the economic analysis is actually based upon a sound footing, based upon data, clear data and analysis, then those kind of decisions being challenged before the superior courts in the country are fairly slim. What is the real large number of government decisions, economic consequences are getting stuck at the courts? Is it because we are unable to take up this particular line of argument to the court, the kind of analysis which we did before formulating a position? Were they not properly communicated before the court? Why are so many economic decisions being, I think, subject to litigation in India?
Unfortunately, what happens, the court cases, there are two parties. And many a times the government regulatory department becomes a party, not the department which is responsible for push on that industry. So the only methodology available is through an intervention there. And any legislation which comes is to be based on a thorough economic analysis of it, because any policy making is a very, very long-term measures. But many a times you have knee-jerk policies or a crisis management policies, and the adverse impact of it starts emerging at a later date. But whenever it comes, I totally agree that there is a strong need to have an economic analysis of it, and that paper should be put forward to the court at the desk. If you look at the cases, if you look at this common cause judgment case, so there were the miners, And then there was the interpretation of law of the Environment and Forest Department, where they interpreted that instead of Forest Act, you should be penalized under the Mining Act. So what was the resultant because of this? This kind of a thing resulted in such a way that the entire liquidity of the industry disappeared for a nearly 8 to 10 months. The government was very happy because there was an additional amount coming in their exchequer. But then that is not the way when you look at the holistic way of the economy. There need to be a balance when we are working upon it and then go ahead with it. A similar point I will like to say is that when we talk about Make in India kind of projects, now in the IT, just because the Defense Act and the IT law were not in congruence, the Indian maker was pushed back and then we were forced to import the goods. Now, these kind of a things, now that there is a clarion call of Make in India, there is a capability in this country and we have to fend for 65% youth. We have to, we have to create 18 million jobs per annum. So with that kind of a challenge, any this of jerk, what is moving smooth, really you see how much back we go into the whole process. So therefore, it is very, very important that any such case coming, maybe, a week can be put forward to come to the economic analysis, and then a quick discussions and the judgment is going to go a long way and weave in this economic thought process into the entire understanding of the judicial judgments which are coming forward. Because otherwise, in this time, when we are 1.3 billion population, a huge market, the world trade is interested in us in the market, but we are interested to be a partner into that trade. And to be a partner into that trade, this kind of missing the bus or delays is having a very, very adverse impact. And I have given few illustrations. I have a long list of such illustrations. But then the point is very, very short, that judiciary is to interpret the legislation, not create a legislation. And while interpreting, the economic analysis has to be a part, at least for consideration, even though it may not be guiding the judgment completely.
Thank you. Thank you, Dr. Sharma. In fact, we have got another 20 minutes, but I would like to have one more round of short questions and then give some time for the audience to ask their own questions. So I'm just taking the point which Dr. Sharma just mentioned right now and asking a very practical question. So we know that a little knowledge is a dangerous thing. So in the context of India, assuming that the courts are going to apply this economic analysis of law or the economic approach of law, I think there are pitfalls as well. Even in the United States, if you look at the practice, only a few circuit courts, the 7th Circuit Court where Richard Posner and Frank Easterbrook, or the 2nd Circuit Board, where Justice Calabresi was there. These are the judges. Very few judges, even in a highly in a sophisticated legal system like the United States, have been able to apply this kind of an approach to judicial decision making. And we know that in the context of even those countries, traditionally a JD holder will also have a PhD in economics. So the judges will have very sound backing and background in the disciplines of both law and economics. But when it comes to India, assuming that the courts are actually going to apply a law and economic approach, do you think that there will be more problems than good? Because sometimes the judge may apply their own subjective method of economic analysis and come to a particular good, which may have a serious, foundational problems. So let me actually start with in the reverse order, starting with Dr. Sharma.
Right. I'll put it this way, that yes, half knowledge is dangerous, but you have a lot of in-service courses for the judiciary. And there I found generally they are addressed, the judiciary addresses the judiciary, or the lawyer addresses the judiciary or judiciary. So it has become more an in-house kind of an exposure. It is very important to get the sectoral experts to come and talk there as well. And, these kind of cases can be then hair split. So that will make them to be updated as to what is the thinking process or what are the impact process that are emerging under the different places. Then another thing, what you have rightly said, like you have a system of appointing an expert and who is supposed to guide the bench on the various issues. Now, that expert table or that expert's insight is an opportunity to listen to the different stakeholders and bring out the whole thing in front of the bench. So these two institutional arrangements are already there, which needs to be strengthened by bringing in this thought process in the mind to have an economic impact outlook also, especially because they are the trade judgments, any judgment which is related to commerce or which is going to hit the employment in this country. So these kind of issues at least should be having this kind of an arrangement, and this kind of a breather is going to go a long way to help and strengthen the legislation, correct the legislation as well as take care that the judgments don't become like an impediment to go ahead with.
Okay, thank you. Now let me give the floor to Dr. Surat Singh.
Well, little knowledge is a dangerous thing, but wrong orientation is more dangerous. What is missing is the orientation. If you say that I look at the black letter of the law and I refuse to look at the big picture. See, the difference between Harvard Law School and Harvard Business School is I was at law school. I took a course at business school. First time I heard the word big picture, which I never heard in 5 years at Harvard Law School. So looking at the big picture so that we can see the interrelationship between things. And there is a problem, which Pinky rightly pointed out, that in our system of separation of power, we say that the policy decisions are to be made by legislature, executive, and only interpretation of the law is given to judiciary. Now, in this separation of power, the idea was power is not abused. But I'm sorry, being a Supreme Court advocate of more than 25 years of experience, separation of power has resulted into separation from power. Nobody has the power to do anything. Court will only order, oh, this is wrong, go back. Only procedure is followed. After 10 years, the case goes back, same officer decides. So it's only a procedural formality. Legislature feel we make the law, but judiciary can strike it down. So it's what kind of strange system we have got, where instead of doing justice, and when we say justice, I have personally Vikramaditya in mind, who you may be saying that all power is concentrated, but who could deliver the justice immediately? In India, so much time is wasted whether this is the right forum, whether the case is maintainable or not. Like after 5 years of hearing, court decide, oh, this court does not have the jurisdiction. What kind of thinking is going on? So I go back to Justice Krishna Iyer. In fact, before Justice Krishna Iyer, famous judge of America, Oliver Wendell Holmes, Pinky will approve, our fellow Harvard Law School judge. He said in 1884, life of law is not logic, but experience. I repeat, life of law is not logic, but experience. Felt necessities of time, prevailing dominant interests, prevailing morality have much more to do with law than the language of the law. So we need to look at the what I call big picture rather than black letter of law. Of course, we can start with the black letter because legislature have said something, but then we have to make sense. And interpretation requires the keeping in view the integrity of the whole system. What is the best possible interpretation we can give looking at the big picture, which makes sense? And if you look at the big picture, in an environmental case, you look at environmental laws, you look at laws of employment, you will look at laws of economic development, you will look impact on other things. So when you look at the big picture, and big picture means looking at the purpose, the goals for which laws are made. You know, Indian Supreme Court, I teach courts, 70 years of Indian Supreme Court. You would be surprised, same language, Pinky, Article 21 has not changed in 1950. In A.K. Gopalan, same language, that nobody shall be deprived of his life or personal liberty except procedure established by law. Just one line was interpreted very differently in 1950 in A.K. Gopalan case, where it
was sorry to interrupt you because we are running a bit short of time.
So I am concluding. Yeah. And it was interpreted in Menaka Gandhi in 1978 very differently. Approach was different. So we have to look at the impact rather than only the language of the law. So the context, big picture, and purpose, all these are to be taken into account while giving interpretation, which will include economic interpretation also.
Thank you. So now let me turn the floor to Bipul.
Thank you, James. Let me answer your question by posing another question. Why can't we have economists and other professionals as judges, at least in high courts and Supreme Court? There are examples from around the world. I can give you one example. One of the most eminent competition economists in the world, Professor Frederick Jenny. He was appointed as a judge in the French Supreme Court. And if we look at some of the judgments which he has given, many of the things which we are discussing today are reflected in his judgments, of course, along with other judges. So can we have that? Is our system going to allow it? I'm sorry to say this. I'm sure there are other examples also. He was there in the French Supreme Court as a judge for, if I remember correctly, for 2 terms. Now, I'm sorry to say this, but is our system going to allow this? To have economists, then you have environmentalists, you have political scientists, sociologists, engineers, doctors as judges in our system, in high courts and Supreme Court at least? Is it possible? That's the question. Now, I mean, you may call me pessimistic or even anarchist, but if I look at one news item since yesterday evening or today morning, that there is a privilege system has been created or is being created in Delhi for the Supreme Court judges and other judicial officials. I'm ready to face anything by commenting on a matter like this.
Thank you, Bipul. I think, in fact, we're running short of time. So,
James, is it required? I want you to answer it.
No, I will. Let me, as a moderator, let me actually answer at a different time and location. So now let me go to Dr. Pinky Anand for any comments with respect to my question.
I stay staunch on a couple of viewpoints. I think the way separation of powers, which was also highlighted by Surat, the way we have to adopt and run our country is that we choose a separation of powers. So you have domains for exercise of powers. What I do think is important is that everybody exercises powers within that domain. Within that domain, there are areas. So let me come to law and justice for a moment. So law and justice itself, only where discretion is possible within the legal system and the law as it is defined. Yes, it could be interpreted and should be interpreted, take into account each of the factors that are important. Not only economic analysis and cost and benefit analysis, but there are social analysis, there are economic analysis, there are environmental analysis. But when there is discretion, only then you can allow these factors to prevail into the judgment-making process. But otherwise, to say that within the legal system as it stands, we can actually import into it a cost-benefit analysis, aside from the discretionary areas, I think we would be heading in a way which possibly I would not understand would be conducive to the rule of law. There is a certain purpose. Mr. Chatterjee's suggestions about having appointments of economists and other professionals, so to say, which is prevalent, of course, in the world. And I was surprised. I remember when I was at Harvard myself, and the professors said they were, appointed as judges, or they would give even legal advice. So the whole question of having such system is something that would need to be examined. But the principle of people who are appointed as judges, or who should be appointed as judges, is the fact that they have general knowledge and experience in the world to interpret according to their conscience and according to the law as it stands. And to that extent, I think we should stand with the system. What we do need to deal with is twofold principles, I think, at this point of time in commercial or economic laws. One, we definitely need to see our international obligations and the enforcement of contracts at the quickest possible time. Two, we do need to weed out delays in the system which are really antithetical to the rule of law.
Thank you. So we have got a few questions actually. So maybe I will direct to the speakers. And
I'll have to excuse myself, James.
No issues actually. So maybe the first question you can answer and then you can exit. The question is, can the judiciary, I mean, while referring to Vedanta, force a private company to function for the public goods, even if it is temporary in nature? So can you address that question?
Even if it is
temporary in nature.
Temporary.
Yeah.
As I said, emergent situation require emergent relief measures. And in the jurisdiction of, let us say, PIL or the concerns of health, there are various possibilities that are there and will be there. I mean, you have, for example, today health camps set up, you have hospitals set up, you're having NGOs, other organizations setting up plans. So yes, everything is possible in those circumstances. And definitely those are extraordinary positions and emergent positions which come within the realm of, let us say, PILs. As I mentioned to you, that's a different domain from the strict letter of the law or the content of law. So yes, it is possible. Whether it should be done or not be done, I leave it to the courts to decide, and then we can see what to comment on.
Thank you. Thank you for your participation. And I've got a follow-up question maybe to other participants.
Thank you.
Thank you. So the question is, please discuss the rehabilitation of affected public due to big projects. How can we make sure that the competing economic and social rights are balanced? So maybe either Dr. Sharma or Bipul, I mean, one of you can answer.
Okay. I'll take this question. There are very sound principles of rehabilitation, and we have examples where rehabilitation has been done very, very well under some of the irrigation projects which has happened. New townships have come up, compensation has been given to them very well, and the new township had better infrastructure, better facility, better access to them. What is important is to observe and a third party to monitor that these rehabilitation process is quick, better, and it improves their quality of life. Another example I'll give you of the Gurgaon. You know, a Gurgaon model where land was acquired, but they also had a share in terms of getting some flats in the housing projects. So in the sense, their income was not one stroke, but they had a multiple strokes of income. So we have this evolution of the rehabilitation package, and I totally agree that if anybody is disturbed, the rehabilitation should not be only at the current cost, but also the futuristic economic losses they will be incurring because of this move. And this calculation of the amount should be given to them and a hand-holding to them so that they can restart their life in the new process. Absolutely no compromise of them, but the entire process has to be quick and to be monitored by a third party.
Thank you, ma'am. So I have a question for Mr. Bipul Chatterjee. The question is, how can we go about training and making sure of a cross-disciplinary approach to judicial in a uniform way?
We have to have a system in place. I understand that some of the law schools, they are trying to have that system in place, and you have to expand it. You have to expand its scale and also its operations. Now, going back to your earlier question, James, if I may answer it or address it, that 3 quick points. First, we have to understand that sustainable development is not just about environment. There has to be a balance between economic, social, and environmental equity while interpreting or while talking about sustainable development. We tend to interpret sustainable development only through the lens of environment. And that is one of the reasons where many of these problems are arising. Secondly, we have to, very briefly, very quickly, we have to look at, talking about this rehabilitation, compensation, things like such issues, we have to look at them dynamically, not in a static manner. At the moment, we are not even looking at them in comparative static manner. Forget about looking at them in dynamic manner. Thirdly, and perhaps most important, we have to understand that the person, for example, let's say you are an environmentalist. You are making certain points, and there are merits, some merits in the points that you are making. I am an economist, I am making certain points. You have to understand that there are some merits in the points that I am making. At the moment, the things have come such a pass, I would say, that I am right always, you are wrong always. And unless as a society we address this, we will keep discussing all these things for the next 20-25 years and will not be able to arrive at any conclusion. Thank you, and over to you.
Thank you. So now I have got a question for Dr. Surat Singh. The question is, there is a direct correlation between social justice and economic justice, and a very large gap between developed nations and impoverished countries. Does social justice encompass economic justice? A fairly broad question. Can you give a fairly short answer to this?
Well, when we say social justice, it includes everything. Economic aspect is part of that. For example, what kind of a justice a person will have if the person does not have access even to the basic needs? So when we say social justice, of course, generally social justice means no discrimination, but it is bigger than that. And economic justice means at least equal opportunity to compete, equal opportunity to learn, earn. All these things are important, and where Dr. Sharma rightly said inclusive growth, that is the aspect. Growth is yes, but at the same time, make sure that as many participants are there as possible. That's why I use the word shared prosperity. Shared prosperity is something which should be declared fundamental right, as earlier right to property was. Otherwise, as in American Declaration of Independence, life, liberty, and pursuit of happiness. Life is there, liberty is there. Where is pursuit of happiness? Pursuit of happiness will come through right to shared prosperity.
Thank you. I think we don't have too much of time to take further questions, but from this discussion we have I think discussed so many issues, starting from constitutional interpretation to using a law and economics approach in trade agreement, in construction and infrastructure matters, and also with respect to social justice and other related matters as well. The one important point is that the economic analysis of law is not a very simple matter. It is a fairly complicated matter. Sometimes it may have to be done in an ex ante manner. Sometimes the judges, while interpreting statutes, will have to apply economic approaches to it. The most important point I think that came out from the discussion is that the text of the statute should not be interpreted in a wooden way. That means the text has to be interpreted by imbuing the spirit of the Constitution, and also by looking at the social welfare, or maybe the shared welfare of the citizenry, as an approach to preserving the law itself. The other important point that came out in the discussion is that the economic approach to law cannot be a static matter. It has to be looked at in a very dynamic manner. And we also need to invest heavily in terms of having trained judges and lawyers who can interpret these provisions while at the stage of preparing the statute and also while implementing the statutes. So we had a fairly good spectrum of views coming from the legal community and also from the administrative side. Thank you to everyone for participating in the discussion. And I think give the floor to.
Thank you.
Thank you, James. Thank you very much.
Thank you, everyone.
Thank you, Mr. Sharma. Mr. Sharma, for your valuable comments. Thank you, Dr. Surat Singh. And thank you, Mr. Chatterjee. And of course, I also appreciate Ms. Pinky Anand. This session, of course, threw open many new questions as well, because the delicate balance between what constitutes legal analysis and economic analysis as opposed to administrative analysis are not necessarily in straight jacket frameworks, and there is a lot of overlapping. And when such overlapping is there, what becomes the role of the judiciary is so critical. So I am grateful to each one of you for sharing a more nuanced understanding and appreciation of these issues. Thank you very much for your time. This session is ended, and we will be starting our next session exactly in 10 minutes on the second thematic session of the day, Law and Economics Approach to Corporate Laws and Corporate Debt Restructuring in India. We'll take a short break and we'll see you in 10 minutes. Thank you very much.